Just a couple of weeks ago, we saw this trend, like the Ghibli trend, where everyone was posting images of themselves or something that were depicted in the Studio Ghibli type of animation style, which is quite iconic. Studio Ghibli, or the founder, Studio Ghibli, Hayao Miyazaki, never gave any consent to AI being able to train on its data set. But it doesn't, at this point, it seems like it doesn't even matter. This technology is pushing through, it's becoming a trend. These are violations of IP that are happening, and we still, as lawyers, want to make sure that that's protected, because a lot of our clients have their own IP, and we want to make sure that's protected as well. When it comes to compliance, we want to advise them on making sure that they don't train their own AI with data sets that they don't have the right to train it on. Any artist or individual or anyone who's created certain IP can turn around and sue them. You just don't want to take your client's information and then just pop it into ChatGPT and create stuff from that, because you don't know where that information is going.
Welcome everybody back to the podcast. Today we're diving into the legal side of entrepreneurship with a special guest who is an expert in corporate and intellectual property law, as well as regulatory compliance for emerging technologies. He's the founder of Amar-VR Law, a Toronto-based firm with a global reach dedicated to helping business owners navigate legal challenges with a modern, solutions-driven approach. From raising capital for startups to guiding companies through compliance and risk management, he provides practical legal strategies that empower entrepreneurs to make informed decisions. Whether you're launching a business, looking to protect your intellectual property, or wondering when to seek legal advice, this conversation will offer valuable insights. Glad to have you on the show, Amar.
It's a pleasure. Thanks for having me.
To kick things off, let's talk about some of the foundational legal considerations. Starting a business can feel overwhelming, and especially for entrepreneurs who are testing the waters before making a full commitment. From a legal standpoint, how important is it for somebody to incorporate their business early on?
I would say it's quite important. First of all, it's really good or important to have a plan in place. Before you make that decision of what kind of legal structure you want to take with your business, whether it's a sole proprietor route, partnership, or the incorporation route, and having that sort of plan fleshed out from the beginning will allow you to kind of make that decision better in terms of how important it is. But that being said, it is quite important. There's a lot of benefits to incorporating early. One, it gives you clarity when it comes to the ownership of the business, the company, and also the assets and everything that's sort of done in terms of operating that business. Intellectual property is huge, right? Some of those assets might come in the form of IP. So making sure that you as the owner, whether you're solo or you're working with co-founders, that you've assigned your intellectual property to the company, so you can go ahead and use that IP for creating products or whatever it is that the company does. And then also, in terms of it limits legal liabilities from the person. It shifts that liability to the corporation because it is its own legal entity. It is almost as if it is its own person. It can enter into contracts. It can be sued instead of you. It also helps when it comes to obtaining grants, funding, investments. It's preferred by grant providers for you to have a corporation set up. So having that from the beginning will allow you to get that kind of funding early on as well.
And I guess how would one know when to actually, like the timing wise, when to incorporate? Because I know a lot of some of my friends, they have business ideas and they talk about it, and they maybe started an Instagram page, maybe like a rough website. How or when would somebody or should somebody like incorporate? Is it once they get that validation and they've tested the waters a bit, or is there like a specific time they do?
Yeah, that's a good question, because although you want to be prepared and have that, sometimes you don't want to sort of uh, go ahead of yourself and sort of get caught up in all of the administration obligations that are involved with running a corporation. It has its startup fees as well that can be quite significant when you're starting out, And to do that and do it at such an early stage where you might not be necessarily ready, could, it could decrease sort of the motivation in terms of whether, this is still worth sort of pursuing. So it's would sort of be in a place where you want to test things out. Again, having a plan in place where you have a series of different sort of metrics to kind of test, like what KPIs involved in terms of, hey, at what kind of level of engagement should we be at? Where should our product or our service be at, for example? And when it's getting to a point where this is something where, let's say, co-founders or a solo owner is looking to take this quite seriously, that's when you'd want to start looking at incorporating, because you formalize that seriousness with creating a whole separate entity. And with that comes its own obligations. So if you are serious about it, that's also kind of an indicator in terms of when you should start doing this.
Okay, it depends on basically how committed somebody is, and how much they've essentially thought through. If they're really confident that they're going to execute and it's not just like a couch idea, then that's basically when they should basically think about incorporating, you're saying?
Yeah, that's fair, because it's taking that leap, right? Once you've kind of set up a corporation, you paid those fees to do so. You now have to, you can open up a bank account for it. There might be additional obligations and responsibilities associated with that. And let's say if you're working or building something with other co-founders, you're going to probably issue shares to each other in some way or another. There's obviously vesting is one form of share issuance when it comes to starting out. But either way, it's sort of staking claim in the corporation, and each co-founder has a pie or a slice of the pie. And so that in itself means that, okay, everyone is committed to this, taking it seriously. And it's not that easy to kind of go back from that.
Right. And I've heard a lot of like, for example, therapists or coaches, they don't have a company that they've incorporated. They're like a sole proprietor. Um, is there still a benefit for individuals like that to incorporate, or um, I'm not even sure why they would not, but what are the different cases, I guess? Have you heard of those?
Yeah, that's those are, key examples where you have professionals in a certain field where they might fall under sort of like a regulated body. Lawyers fall under that as well. You have doctors, dentists, where you have to be professionals. You belong to an organization like with us, the Law Society of Ontario. So we're regulated by this governing body, and we're we operate a business where we can't really operate a business with, say, non-lawyers or non-paralegals. It has to be someone within that sort of space. So going and operating a business as sole proprietor has been the norm for a long time, and it's only recently that such changes have been made for lawyers, for dentists, for other practitioners, where they can go and open up a corporation. Now, the benefits with that isn't necessarily that it limits liability, which it can for some professionals. But because of those bodies that they belong to in terms of self-regulation, they don't allow some of that limitation of liability, because, like lawyers, for example, we have obligations, and we can't use a corporation to sort of hide behind for that. So the benefit really comes down to sort of tax planning, but also the ability to sell your business down the road. Sole proprietors, technically, you can't sell that business. You can sell the individual assets that business might own, but you can't sell the entity. You can't sell shares in a sole proprietorship. So with these types of businesses, setting up as a corporation makes it easier to bring on a partner, for example, or sell your business to someone else who might be in the same profession as you, with much ease than doing so as sole proprietor.
Okay, yeah, no, that makes sense. Um, And a lot of early stage entrepreneurs, they try to minimize costs, and that often includes legal fees. So for things like NDAs and contractor agreements, website privacy policies. Can business owners create their own legal documents using tools like ChatGPT, or um, do you think they should consult a lawyer for those type of documents if they are on a budget, let's say?
Yeah. I know it's very difficult when it comes to budgetary requirements and constraints, especially starting up as a business. But at the same time, as a lawyer, I wouldn't recommend anyone to go and do it themselves without any sort of, kind of consultation or guidance with anyone who's professionally legally trained. Now, in the past, we've had, there's a lot of services out there that provide, say, quick and easy templates, like Law Depot, Rocket Lawyer, and those have kind of made it affordable to use some standard types of agreements like NDAs, which don't really change too much, and you can get away with those in a lot of cases. So in that kind of situation, there are certain types of documents or agreements that are better suited for, let's say, DIY, but using the right types of documents. And there's obviously different types of agreements where I wouldn't recommend that at all, right? And we're looking more at shareholder agreements, certain types of contracts between parties, like publishing agreements or service agreements, for example. And now with ChatGPT and all these AI services that have amazing tools that can generate certain types of documents like this, it's made it. I think it hasn't made it any better for the individual. I think it's just kind of increased the risk because now it seems like it's better and more tailored to what the situation involves. But at the end of the day, AI is still a tool, and it's best used by someone who has the legal or the knowledge and the understanding of how to actually use that tool for that particular purpose. And so, you have with these types of tools, you can get into situations where the contracts aren't used correctly, or they, still AI sometimes hallucinates or can cite certain laws that might not actually apply given the jurisdiction we're in. So jurisdictional issues are something that the common individual might not sort of necessarily think about when it comes to a contract. They think, hey, I just need this agreement, but they might not realize that the laws that are actually implemented in this might apply to a place like the United States. It might not necessarily apply in Canada, or to be even more specific, Ontario, because we have those kind of jurisdictional limits as well. So it's a great tool. Lawyers do use it, but it's best to be used by someone who knows how to use it. And if you do go and use that kind of a tool, definitely get a second opinion from a lawyer.
Okay, yeah, that for sure makes sense as well. And I guess for some of the listeners, if you have any examples of what are some like common mistakes or what issues you've seen come out of business owners using it themselves.
Yeah, so I've seen, and this kind of applies with, even before AI, sort of two common types of mistakes or issues is the incorrect type of document or agreement that's used for the situation. At the end of the day, you might think you know what agreement or document you need, but that might not necessarily be the case. For example, I hear, hey, I need a partnership agreement all the time just because two different parties are involved. But they're really a partnership agreement, if you really think about it, has to do with two parties forming an entity as a partnership, right? Rather than engaging in some sort of a services exchange or something like that. And so we want to know specifically what it is that uh, the parties are actually getting involved in, and making sure that they're choosing the right type of agreement or contract for that situation. And again, that takes someone who understands or has done it, has experience, and knows what kind of agreements come in place. Obviously, with that comes like the implementation of that document or that agreement. Is it even being used correctly? Is it even enforceable? And then the second type of common issue is, we see Frankenstein, what I call Frankenstein documents, where they're cut and paste of different types of contracts that are found online, or, have run through ChatGPT or something to sort of add their own sort of customizations to that. And you might get something that looks like an enforceable and legitimate document, but in the end, it might not be. And unfortunately, you don't usually see, or you don't usually find out that this is the incorrect type of document until it's too late, and that's when you have a dispute. And in those kind of situations, you often do have to bring in lawyers to help resolve that, and that can be far more costly than just going with the lawyer at the beginning and just having the right type of document in place.
Yeah, and I know on your website you do have a blog called "Can I use ChatGPT to write my contract?" So, yeah, if anybody listening wants to, I guess, hear more about that, they can definitely check that out. And then just moving over to compliance and AI regulations, I saw you offer compliance services on your website, and I saw generative AI regulatory compliance listed. So, with essentially AI advancing so quickly, what are some key legal considerations that business owners who use AI in their operations or in their products, what they should essentially consider?
Yeah. Um, it's like AI is just evolving so quickly. And what was, when I initially kind of came up with these services, this was almost 2 years ago, I guess, when like the original Chat GPT-3 came out. That, along with all these other types of generative AI technologies like Dolly, et cetera, which are being used by a lot of, say, individuals in creative spaces. And so a big portion of my clientele are actually creatives. They're in the video game space, and in the tech space as well. And so they're creating new assets all the time to implement into whatever product that they're creating. And it's just so much easier for them to be able to duplicate, replicate, create something new, augment, with something like Dolly or the technology that OpenAI has. Um, and the problem with that was, at that time, was everyone was talking about copyright and IP infringement. And since then, we've kind of talked about that. We had some lawsuits. Few countries and jurisdictions, including Canada, started to come up and table different legislations for that. So Canada, for example, we had the artificial intelligence, the full name of that, Artificial Intelligence and Data Act, also known as ADA, and that was tabled. They were going to make some revisions and amendments to that, but it hasn't actually passed. And with like the politics that we have at the moment, we don't know when it will be. And this has happened in other countries as well, where they have their own sort of policies when it comes to AI, and they're trying to catch up, but AI just keeps evolving at such a quick rate. So, our services with this have had to evolve as well, um, because before it was more of an issue about intellectual property infringement, which I can chat about as well. But now we're getting into a situation where um, the data on which it's being sort of trained on, and the data that people are inputting into these tools, they're just doing it, and we don't really know what's happening with that data, who's collecting it, who's buying it, who's storing it. Um, and it's kind of at a point where it's just very, very difficult to keep in check. So we still kind of want to use a rule of thumb when it comes to advising our clients and making sure that they're in compliance. That at the end of the day, it's not really about taking shortcuts, but it's also about respecting their clientele, right? Their privacy information, their data, and knowing what kind of information they're inputting into these tools. And with intellectual property, with generative AI, what information is that being trained on? Are they infringing on anyone else's intellectual property? Like just a couple of weeks ago, we saw this trend, like the Ghibli trend, where everyone was posting, hopefully not everyone, but quite a few people were posting images that of themselves or something that were depicted in the Studio Ghibli type of animation style, uh, which is quite iconic. And the thing is, Studio Ghibli, or the founder, Studio Ghibli, Hayao Miyazaki, never gave any consent to AI being able to train on its data sets. But it doesn't, at this point, it seems like it doesn't even matter. This technology is pushing through, it's becoming a trend. And so these are violations of IP that are happening, and we still, as lawyers, want to make sure that that's protected, because a lot of our clients have their own IP, and we want to make sure that that's protected as well. So when it comes to compliance, we want to advise them on making sure that they don't just train their train their own AI with data sets that they don't have the right to train it on. And then they're not infringing on the rights of others, because any artist or individual or anyone who's created certain IP can turn around and sue them for infringing their IP without their consent. So that's one huge thing that's been consistent in terms of making sure we advise them on. But like I also said, just the privacy and confidential information of their own clients and the data that they're putting in there. You just don't want to take your client's information and then just pop it into ChatGPT and create stuff from that, because you don't know where that information is going.
Yeah, I find that really, really important. And do you think just like removing the confidential details, like for example, their name and business name, but still using the information, have you heard of incidences where it's still quite dangerous? Because ChatGPT might be smart enough to essentially piece information together to connect the dots.
Yeah, honestly, I'm not really sure, right? And it's not that I'm not sure in terms of uh, whether it's okay or not. It's more so we just don't really know the capabilities, or I don't know the capabilities of what AI is able to do at this stage today, and how that might change tomorrow. Um, we when we're inputting information, we're probably creating our own sort of patterns, or ChatGPT is able to sort of create and acknowledge the patterns with each individual user. And based off of that, they could probably find, different situations, even though we use different names, it can probably piece it together and create a narrative. And you can probably see that with the way that ChatGPT is able to create tailored responses to what you put in there. I think just recently it's got a feature now where it remembers all the inputs that you put in on other chats that you've had with it, not necessarily in the one chat feed. And so again, we just don't really know what's going on behind the scenes there, because usually there's a lot of testing. There's a lot of it's almost as if what we see in terms of what's available to the market is just a tip of the iceberg in terms of what's actually what the AI is actually being trained on internally. So it's quite scary, and it's best to just err on the side of caution. If you are in a business where you're dealing with the privacy and confidentiality of your clientele, try to stay away, or at least monitor the kind of information you're putting in there, and don't neglect human oversight as well when it comes to using any type of AI tool.
Right. And I mean, it's so great that you have a niche where you actually focus on like companies that use tech and the gaming industry, so that you're always up to date with it. I feel like you'd be the best person to essentially go to regarding that, since it is part of your job to stay up to date. Um, there has been a lot of discussion around the ethical use of AI, and what should businesses essentially be doing now to ensure that they essentially stay compliant with all the current but also future regulations?
Yeah, it's the laws are like when it comes to kind of seeing what the trends are with the law and how it responds, typically we look at what are the current cases or court cases that are happening, what are the lawsuits that are involved, and what those decisions are from those lawsuits, because they'll shape how the laws will be developed around that case. Secondly, governments will pass their own legislations and turn them into statutes, which will be essentially codified law on that. And like I mentioned earlier, the Artificial Intelligence and Data Act, that was supposed to be something in Canada that would have created a set of laws in terms of how AI is supposed to be used and used essentially within Canada, but that hasn't actually come to pass, and we don't know when it will. And then we have situations where companies will go and use AI unchecked, and it's only once they've broken something or someone responds to them, reacts to them in a way where we actually take measures to either through a lawsuit or have, say, regulation, self-regulation within certain industries. So like tech companies might have to come in and self-regulate in terms of what they do. But that's not always reliable. And sometimes we see a tug of war between lawsuits, between the governments and their legislations and the industries in self-regulating in terms of who takes the lead in coming up with the laws in this case. And then when you take all that with just how fast AI is evolving and not just in terms of the technology, but the implementation of AI by different businesses. It's just so hard to keep on top of that. And so, as lawyers, we have to keep an eye on what these trends are. We have to keep an eye on where our clients might be, potentially exposed to legal risks in terms of how they implement the AI, because we're not at a point where we can advise businesses and business owners not to use AI, because using it is a competitive advantage now. So if we can kind of advise on just sort of policies and procedures that they can implement internally, that'll go a long way. And that includes just being transparent with the type of AI that's being used internally, not necessarily with your clientele, but within your team. Knowing how AI is being used among your staff, for example, because you might have policies in place, right? And this is where oversight comes into place as well, in monitoring. But you might have policies in place, but one of your employees might just end up using, say, a certain type of AI tool, which your company doesn't allow or is still very experimental. And so, just as an example, maybe OpenAI's ChatGPT is something that a company has policies around and is comfortable with using and knows how their clients' information details are going to be used in that kind of case, or even something like Microsoft Copilot. But with new parties coming in, like DeepSeek, for example, that come from other jurisdictions where we're not really sure what the laws are around there, if that starts being implemented by one of the employees, that opens up potential risk for leakage of information, or just not knowing where that what's being sort of implemented and used within your company. So that kind of oversight, having policies, implementing them, and staying on top of that, I think is key. Having open dialogue about the use of AI within businesses is also very important. And I think that kind of ties that all together in terms of policy implementation and oversight.
One thing I really love about these conversations is how real they are. Just honest stories from people who are building something out of nothing. That's exactly what inspired Click Digital Empowerment. If you're a small business owner or a solopreneur, we're actually going to be offering 10 free business audits, whether that's on your marketing or your operations, as well as a recommendation report with 3 different strategies on how to improve your business, as well as 1 free consultation. It's a simple step that could unlock real digital growth, and it will give you a good idea of how our services actually work. Just head to the link in the description where you'll be able to find a form to sign up to see if you are one of the first 10. Now back to the video. And just like regarding like the policies, there are different policies to keep like customer information safe, like privacy policies, email, the marketing email lists, and other ways that companies collect customer data. So, I guess how important are those? And um, are there any specific ones that companies should definitely use, like are just common practice every, let's say, website or marketing email list should have?
Yeah. So there's certain laws in Canada, and it's been around for a while now, like the CASL, we call it Castle. That's sort of the policy when it comes to email marketing, chain mails, etc., where you have to receive consent from anyone to subscribe to, let's say, your newsletter and to receive newsletters. That also requires a way for whoever might be receiving that a way to unsubscribe as well. So these types of laws are actually in place. Um, they actually, because they've been around for a while and are so entrenched into sort of the way businesses operate and conduct marketing. A lot of third-party services like MailChimp and other platforms that help you do newsletters, they kind of have all that built in and sort of take care of that. So that's one thing I would recommend, but a lot of the times that's already sort of in place for you. Privacy policies are also key, and they're a must. Now, a lot of platforms, and again, let's say you're an e-commerce platform and you're on Shopify, they have sort of boilerplate terms for privacy policies that you can use. And those are fine. But as you start to get a little bit more sophisticated in terms of what your business is, you want to start tailoring those privacy policies. And I think that's sort of the key in terms of the difference between what companies should have. It's not so much what they should have. A lot of them are available, as I said, as sort of like templates and boilerplate policies provided by the platform in which you're providing your business. But being able to tailor that to what you need specifically towards the type of information that you collect, for example, with privacy policies. If you can be very specific and more tailored to that, the more protection you're afforded. So if you think about it in terms of liability and risk, the more broad something is, the more room there is for potential exposure to risk. The more tailored and specific something is, the more you're likely to be covered by something. Because at the end of the day, with these types of policies, especially when you're dealing with client information, their data, it's always important to be very transparent with them. And that's why with some privacy policies that are comprehensive, you can just see with the language in which they're drafted that it's quite approachable. It's usually associated with their brand, and it's very transparent about what it is that they collect. And you might be surprised to see what it is, what the data is that they collect and how they use it. And sometimes that might be problematic for that particular user, but they're transparent about it at least. And that's more important than hiding something and still going ahead and collecting that kind of information.
And a lot of the times I find that companies, they just include a small hyperlink at the bottom, and it's usually very kind of, you can't really read all the details unless you really go in depth and go click. So how do you find, like nowadays, because data is so important, do you find that it will actually benefit the company to be more transparent and to showcase that they are taking that initiative to try to make the language more understandable for potential customers? Do you think that's actually a bit of an advantage?
Um, yeah, so like what you're referring to is, like tick a box or click on this link to go to the privacy policy and terms and conditions, and by sort of clicking that box, you assume
Yeah.
that you have, right?
Mm-hmm.
Yeah. Yeah. The law kind of allows, like, at the lowest sort of level, just to sort of get past. That's what the law does allow.
Oh.
It can be considered, informed consent. Some jurisdictions that might be different. But as long as those links go to the terms and conditions or the privacy policy, and that tick box is there to kind of confirm that, and if that user clicks on it, they're basically saying that they have reviewed it, and that is problematic for sure, because most of us probably don't, right? Especially when we're installing a new app or something, or we just got a new product and we just can't wait to use it. We don't want to read, tens of 20s, 30s of pages of legal jargon just to use our thing, and we don't even know what we're reading. So it is still quite problematic. And I think the way business is going, it's hard to say what I would sort of recommend, um, in terms of, let's say, effectiveness and the ability to run your business really well. But what I would sort of say personally, and what I typically advise my clients is, business isn't about cutting corners. It's about trying to deliver a high quality service or products to your client. And that's not necessarily the service, it's not necessarily just the products, but it's also the experience that you're providing to your clients. And you don't want to just have them, on a one-time basis. You want to be able to build a relationship with your clientele that's long term, right? You want them to come back, obtain more services, you use your services on a long-term basis by subscribing, or buying products in the future. And along with that trust comes with transparency and being able to speak with your brand in mind. So what I typically advise is, you know, although you can pass with that tick box, that check box, and that should sort of do the job. If you can implement it in a way where clients are given a sort of a smaller, easy to understand type of privacy policy or terms and conditions that is at least like a summary for them, right? You can still maintain the long version that's has all the legal jargon, but if you can also have one where uh, users are able to kind of get the gist of it, you don't want to sort of you want them to still kind of know what it is that they're working with here, and they'd appreciate you as a business a lot more as well if you take that extra effort. Because at the end of the day, clients want transparency, and they don't, or customers want transparency, and they don't want to be in a situation where they have to actually use those terms and conditions because they want to sue you or they have a potential dispute with you. So it's really about kind of going above and beyond. Of course, there's costs in terms of simplifying that language. Um, but if you come in with sort of a brand and approach, um, I think there's a lot of advantages to using legal tools or documents like your terms and conditions and your privacy policy as a way to uh, sort of strengthen your brand, sort of using what people typically not have no interest in reading, but then taking a different approach where they're looking at this document and saying, okay, this company actually cares about us and what they do with our information, or about getting our informed consent. So it's a tactic that can be used.
And I also saw something actually recently, I think it was last week, where it was the checked box method, but it was mentioning how if you don't check the box, essentially it's assumed that you do agree with the privacy policy and you do agree with being signed up on the newsletter and email subscription, for example. Have you seen that before? Because I recently saw it for the first time, and I thought it was
Yeah.
an interesting way to get someone's consent. Um, so, I mean, what are your thoughts on that? Just like first time hearing that, I thought it was pretty. At first, I thought it was like that's pretty smart of the business to do, but
Yeah.
it also might help the the person reading and checking the box, they don't actually have to do an extra click, right? So you're saving their time. So I didn't know if it was like a win-win, but then I also saw some like ways where the customer might feel almost like a little kind of like, wow, you didn't put that much effort, or
Mhm.
I don't know, like what are your thoughts on that?
Yeah, I mean, I haven't like seen that specific situation, let's say. Um, but I have seen situations that are very, very similar. And to be honest with you, actually a lot of terms and conditions operate in that kind of way. Um, and what they'll say in the actual body of the language is, you know, especially when it comes to, let's say, like there's been an update to the privacy policy or an update to the terms and condition, it'll have language in there where it doesn't necessarily require you to go review it again and click the box again. And if you don't do that, it'll prevent you from using it. It'll say something along the lines of, it's your responsibility to review this to see if there are updates. And if you continue to use this after there's been an update, then we're going to go with the assumption that you agree still. And so that's still kind of similar. And using that kind of approach, um, companies are or businesses are limiting their liability and they're putting that responsibility on their customer or their client. And so yeah, it's the way you mention it is probably like a different kind of take on the same thing. And so it is done, right? The question comes into, how is this sort of tested in court though, when if there's ever to be a lawsuit, and say where someone says that, well, um, I didn't actually give my consent, and the duty is on the business to at least notify us of certain updates or to provide us with a different option. But unfortunately, the other option is often, well, delete the app, delete the service, don't use it, and then that's it. Which, if it's a business that has a lot of, market control, is used by so many users, for example, like with our cell phones, we almost, if we have an iPhone, for example, we almost always have to accept the updates and the terms, because how else are we going to use our phone? We're not going to go, back to like a Nokia or something, or switch to Android, which has very similar terms. So we kind of get stuck in that, and I think that's a bigger legal question, a bigger legal problem in terms of, consumers being tied to products and then being uh, not really having consent in terms of the terms and conditions that are there. But that's a whole other sort of topic and legal issue. Um, but yeah.
Yeah, no, it does sound like it does get quite complex. And I think at the end of the day, it's always best for businesses to put customers first and see how they feel. Do they like that, or do they not like it? And then kind of going from there. But yeah, I did find that really interesting. So I wanted to just get your thoughts on it. Um, and you did mention as well, like legal documents, as everybody already knows, there's a lot of like technical like jargon, and it makes, the person reading it like not want to read it essentially and just like
Mm.
quickly um, provide consent. But why are they traditionally so complex? Did it always start like that? Did it have to end up going that route because different cases in courts? How did that happen?
Yeah, it's what you basically said towards the end there. But as one sort of example, there was I remember seeing some posts on LinkedIn by a video game developer who had some really popular games back in the early 90s, or I think it was late 80s. And he was posting and he says, look, remember this game? It was so successful. He says, this is the contract, right? This is the agreement we had on it. It was one page. It was like two paragraphs long. That was it. That was the publishing agreement at the time. And he says, oh, how simple times were. That's all we needed, to slight, the kind of publishing agreements we have today, which, depending on the game, these are hundreds of pages long sometimes. And so it's like, how do we go from there to there? Well, unfortunately, the quick answer is lawsuits, right? It's litigation. It's the problems, the disputes, and everything that was caused because um, that that short amount of language didn't consider all of these situations that can happen. And business has become so much more complex. There's so many different scenarios that can occur now. And nowadays, um, after, for example, like COVID happened, and also now with like AI, you're starting to see contracts bring back like force majeure clauses into them. So adding a whole other paragraph, or now um, you have sections and clauses on how to use AI properly, or how parties can use AI, or what happens to the assets that are sort of created using AI. So the more complicated the world gets, the more complicated these documents get, unfortunately, because they're trying to account for all these different types of situations. Because if you don't, it's a gap, which would take you to litigation, and there's a lot of back and forth going between the parties, may end up in court, and then the costs are often very expensive. So unfortunately, the costs of drafting these longer contracts at the outset are still a lot cheaper than what the cost might be when you're going to court to argue over certain interpretations of what's on the agreement.
Okay, so yeah, there's definitely, I guess, pros and cons. And and I think from what I heard you mentioned, it is okay to kind of write a simpler version, but then kind of link it to a more complex version for the person who needs to essentially provide consent to do. Is that right?
Yeah, it's sort of an approach that, let's say, a lot of like bigger tech companies are taking. So like, for example, like with Google, they're a big company, obviously, that owns different sort of other brands like YouTube itself. And you'll see, if you start looking at their privacy policies and all of their terms and conditions and stuff, they have so many different guidelines, right? Like they'll actually have the terms and conditions, which is significantly long, and it's broken down into different sections. Then they'll have something like community guidelines, which are sort of like an easy summary for people to read and get to understand. But then they're linked to those longer legal uh, bodies of documents. And so it's good in a way, because as long as you're making it clear that the simplified version is not the actual legal document, it's a summary provided to help you understand, and is to be read in association with the longer legal document. Um, it's a little bit more work, but it's allowing your users, your customers, to be able to get better understanding, and to them that does mean a lot.
Yeah, for sure. And you also mentioned a little bit about intellectual property in the beginning, and I wanted to also just um, ask for that, as some businesses, like, they have ideas, and I was just wondering, like, at what point should a business owner really start thinking about safeguarding their intellectual property?
Mhm.
And do you think it's only necessary for businesses offering a unique product, or is it something like every business should consider?
Um, I think, obviously, depending on the type of business, intellectual property can be much more core to what it is that the business does or provides. But that being said, every business has some type of intellectual property, whether it realizes or not. And that really gets associated with, like, let's say, the brand of the company at the for very sort of basic level. Um, and so if you think about the different types of intellectual property that they have, for example, in Canada, it's primarily, you have copyrights, we have trademarks, we have patents, and then we have something called trade secrets. The first three have um, stronger bodies of law to kind of protect that. They're often litigated as well. Like we have the Copyright Act of Canada, we have the Trademark Act of Canada. that sets the rules for that. And but we also have, intellectual property like trade secrets where there isn't a formal sort of statute for that, but it's still very, very important. Now, trade secrets can be any kind of information that, yeah, even information that a business has that gives it a competitive edge. This could be like client lists, for example, distributors list, certain types of information that you want to keep away from your competitors. Like the most sort of famous example is Coca-Cola's secret ingredient. That's a trade secret, right? So it's not protected by any Copyright Act or anything like that. It's a secret that's been maintained and protected just by the way it's been protected, right? So like measures taken by the company to protect it, where it's located, who has access to it, stuff like that. Probably also internal penalties for the breaking of confidentiality when it comes to that kind of information. So it really does depend. Tech companies, especially, like I've worked with a lot of like bio tech companies and med tech companies. They have inventions that are patentable, so they would start looking at getting those protections there, right? And patents are quite costly, very costly when it's compared to the other types of intellectual property when it comes to protection. And I also work with video game companies where copyrights apply to a lot of the assets that are developed there. So these are, two types of clientele where it's highly recommended. It's almost essential. But there's also businesses out there that are building a really important brand, right? And this could be a business that's, let's say like a psychotherapist business who provides professional services through a corporation or even as a sole proprietor. They might have a business name for their brand that their customers know them by, and it can be quite strong within their market. So they might want to start looking at something like a trademark, which is also intellectual property, and protecting that. So a lot of businesses that get up, they have a brand, they want to start a brand very early on and protect that. They might start looking at getting a trademark registration early on as well, so that they can secure and protect that brand before anyone else takes it, but also to prevent it from being manipulated by another party as well. So it's important for all different types of businesses, but we just want to make sure, this is where like a lawyer comes into play. We get to know our clients a little bit better, assess them, have that conversation about the different types of intellectual property, and ultimately how that IP brings them value and why it's important to protect that value right from the onset.
Right. Yeah. And for entrepreneurs who aren't, I guess, ready to hire a full-time lawyer, are there any cost-effective ways that they can still protect themselves legally? And do you usually find that if somebody does go ahead with a lawyer, they should essentially maintain that relationship because the lawyer would essentially know all the different updates along the way?
Um, yeah, when it comes to costs, the protection can be quite expensive depending on the type. As I mentioned with copyrights, it can be quite low cost. So understanding how to register and protect copyrights is one way to do it. On our website, actually, because it is very straightforward to register your copyrights. You can go and do so through CPO's website, and that's the Canadian Intellectual Property Office. They have their website. That's where they have a portal where you can register copyrights. You can also make claims, and you can also register trademarks as well. Trademarks, though, is a little bit more sophisticated, and I would recommend working with a lawyer or a trademark agent at the very least to do that, because they're very specific. I've just seen so many situations where trademark applications are filed, right? But then there's a process before it actually becomes registered, and sometimes that registration is not complete because there's some sort of an objection because that application wasn't filled out the right sort of way. So And then there's going to be additional costs with that. So there really isn't any way to kind of cut corners there. But copyrights, for example, it's a lot more straightforward. On our website, we actually have a blog that kind of walks readers through how they can do it if they do want to do it on their own. Obviously, we can help out with that as well. And so those are kind of the low cost sort of ways that they can protect that. NDAs, confidentiality agreements, are another sort of important way to do that. Not necessarily with external third parties that you might be in conversation with, but internally. So with your employees, contractors that you might be working with, having confidentiality clauses in those in employment agreements or contract agreements. Those also are easy ways to make sure that that's protected internally without additional costs.
And for the listeners, what is your website where they could actually check out that information and some of the blogs that we mentioned a bit earlier?
Yeah, so it's at www.amarvrlaw.com, and that's AMARVRLAW.com. And basically, we have a big blog section that's divided into the different type of practice areas that we have. And that's corporate commercial, intellectual property, startups, video games and entertainment. Then we also have two other sort of sections that are more specific to area types, but not necessarily what we practice in. That's employment law and privacy law as well. And basically, we've kind of created a library of resources. It's not legal advice, obviously, but it's to inform the readers so that they have enough information to know about these laws, especially new businesses that can't retain a lawyer on a long-term basis, but want to have the basics down. There's a lot of information that they can use to start planning with. And so when the time is right to meet with the lawyer, you can come and do so with a much more informed platform. And it makes that connection working with the lawyer so much more easier because you understand that, and they can kind of cut to the chase with what you need help with.
Yeah, no, yeah, thank you so much for sharing all the helpful resources that people can check out. I feel like a lot of the legal jargon definitely makes me at least feel a little bit intimidated. So I always find it helpful to go online and do a bit of research, but then have somebody that I can always go to that I trust. And yeah, everybody listening can definitely check out your website and your contact details. Are they all on the website, or do you have like a specific way that they could contact you if they do need to?
Yeah, so it's most of the information is on the website. Some you can also Google our firm into Google, and our business will show up there with contact details as well. We're present on Instagram at Amar-VR Law, and we're always posting different tips. We have like tips of the week for different practice areas there. Trying to keep top of mind of the different types of blogs we have that are available. And we're also present, me personally, as Amar Sidhu, that's my full name, on LinkedIn, and also the firm as well as Amar-VR Law on LinkedIn as well.
Okay, awesome. Yeah, I think the listeners, if they do have any questions, they should definitely check you out. And I will also be including all the details below in the show notes if anybody wants to access it. If they're like on YouTube and watching, I'll add it to the description notes. But as always, if you enjoyed this episode, don't forget to subscribe and leave a review, as it allows us to keep coming back with even better guests. And yeah, thank you all for tuning in, and I'll catch you in the next one.